whereby Katiso Molife, Michael Puletau, Museke Kane,
Your signal is very bad, Witness A. Are you? We've lost you. Witness A, can you hear me?
Yes.
Can you just repeat what you said about the suspects? You said Katiso Molefe. Continue. No, we can't hear you, Witness.
Should we adjourn and see if the connection
I would be indebted to
cannot get
Commissioners.
better? Let us adjourn.
established connectivity. We're good to go. Thank you.
Thank you, Chair. Witness A, are you there?
Yes, Commissioners, I am here.
Thank you. Is there anything else that I think you were still addressing the issue of Kat Matlala, Molefe, insofar as the 2022 murders are concerned. And we lost you, so I can't even tell you. And I know you were talking about the suspects and in relation what the murders related to or the charges related to, but could you just repeat that part about the charges and then continue from there, please?
Oh, yes, I was saying the brief that I can say is that they were also charged on the Santin case. It will be Santin case 398. But I said then witness B will elaborate more further on that. There is now the charge where a murder case where they were linked. All four of them, they are in Vereniging Swart murder case, and then they are appearing on this one as a set. And then may I please not deal with a lot of details because I do not have them before me.
That's fine. Can I just understand when you say with this one, what is Santa 98? No, witness A, we're having an issue with your signal again. We might.
Let's take an adjournment and come back at 1:45.
Thank you, Chair.
Adjourn.
Trust you had a good lunch. We are ready to start. Thank you. And please make sure your cell phones are off. Thank you.
Ms. Siegels-Ncube, I trust that connectivity has improved now.
We trust so too, Chair. Witness A, are you there?
Thank you.
Yes, Chair, I am here.
Thank you. Witness A, the next topic in the chronological timeline that we were dealing with the SWART investigation is Mr. Molefe's appeal, bail. Can you just go to page 32 and it starts at paragraph 101 and let me know when you're there.
I am there, Commissioner.
So we know that Mr. Molefe was arrested on the 6th of December and then his first appearance was on the 9th of December. Do you recall when he had applied for bail?
I see here that on the 9th of December, he was at court. Then the legal team indicated that they would apply for bail to the prosecutor. I think then the case was remanded to the 13th of December for such.
Okay, and do you know? Please go ahead.
And then on the 13th of December, if I can just read that into the record. However, on the 13th of December 2024, the matter was postponed at Molefe's request. The magistrate noted that the matter will be postponed to the 21st of January 2025, which was then now the year that was to follow. Because Molefe's legal representative had to validate and verify information because Molefe must show exceptional circumstances that exist for him to be granted bail as he was charged on a Schedule 6 offense.
And can I just understand what is the Schedule 6 offense that he was charged with? I know there's murder, but is there an aggravating circumstance attached to that murder for it to be Schedule 6?
He was charged with murder that was of aggravating circumstances and what will be also termed as premeditated, in a sense that it was a pre-planned murder where extreme force was also used in terms of going back to the crime scene, what it was described of Mr. Ahmad Swart.
Okay, you can continue to complete that sentence. Oh, please continue.
So, in as such, we were advised by the prosecutor that was doing the case. It would be up to him to satisfy the court that he prohibited or he exhibited the circumstances that will allow him or that will be exceptional to the court for him to be granted bail.
Okay. Do you want to continue with 103, the last sentence? The matter was?
The matter was then accordingly postponed to the 21st of January 2025, but the bail application was not heard on that day. It was set down for 20th of February 2025. Then on the... Yes, Commissioners.
Please proceed.
Then on the 20th of February 2025, yet again, Mkhwanazi's representatives, the legal team, sought further postponement. The date was then arranged for the 24th of February 2025. The postponement was occasioned by Mkhwanazi having side of the investigators' affidavit that was opposing the bail for Mkhwanazi.
When you say the Mkhwanazi had sight of the investigator's affidavit, are you referring to witness B's affidavit opposing bail?
That is correct.
Yes. Okay.
They had seen the affidavit, and then in that affidavit, if I will remember correctly, they were surprised by the investigating team or the information that was seen in the affidavit that the investigating officer, which is witness B, was actually aware of his arrest that had occurred in the UK. And then I should also just mention that when they came to court, initially they did not disclose to the court that he had a previous conviction outside the boundaries of the country. And then we believed that maybe they thought we won't be able to trace it because the SAPS is not connected directly to the systems of other countries. They thought it would be difficult for us to trace his previous conviction unless it was them who disclosed it to us, which is what they did not. Because sometimes it is the questions that you ask from the witness to say, do you have this? What is your condition in terms of him applying bail? And then there will be where the onus will be upon him to disclose, either to the court directly or through the investigating officer, to say, I also need to disclose this to you that I was arrested for this, or I have a pending case that is going on at a certain court that you are not aware of. I just need you to know that there is this. In this instance, he did not do that. But we had our ways to investigate that using the agencies that are able to communicate with other law agencies that are outside the country, that provided with information that was very accurate, which we then brought it to the attention of the court.
And what was that conviction in relation to?
This conviction was in relation with the fact that he was found in possession of a dacha, which is cannabis, and then he was arrested in the UK laws that prohibited the dealing in cannabis. And then I think it extended to him being found to be in possession of a certain caliber of a firearm that it was also prohibited in the United Kingdom at that time. So the legal team struggled with that information to say, it was not disclosed to the court. Actually, it was the prosecutor that brought it up with the magistrate, but the applicant did not disclose this to the court. And then they worked up a plan to say he had just changed the legal representative. And then they said the first legal representative that he was using, or he was utilizing, knew that. So they thought, they were of the belief that he had already disclosed it to the court, which was not the case. And then they went as far as obtaining an affidavit from that particular representative to support the claim of the new legal defender of his.
You also mentioned in your affidavit at 104 in dealing with that conviction that there was a passport involved. Can you tell us about that?
Yes, we also could detect that there was a passport that he used in order to travel to United Kingdoms, and then it was also seen that that passport was fake. It was fake in a sense that it depicted the wrong names. It mentioned him as a Libita David Tebucho. Libita will be the same name, so it will be David Tebucho Libita, with a different date of birth from that he is having. And then we asked him that, is he a Lesotho national? Then he told us no, he was born in South Africa. He had never been, he's not a Lesotho national. So it means that he used this document, the travel document, fraudulently to travel to the United States at that time. And then it was an issue for him to say, if you can be able to fake the travel between nations or between countries, these two countries, it will mean that now you don't qualify to be granted bail. That is now an argument that is made by the prosecutor to the magistrate.
And were you present during the bail proceedings, the first bail proceedings?
Yes, I was present.
And in paragraph 105, can you perhaps just read that into the record?
Yes, Commissioners. Paragraph 105 will read as follows. On the 24th of February 2025. 2025, my apology. I'm seeing there it says 5 and 24 March 2025. The bail application was finally heard before Magistrate Morton in Vereeniging. On the 2nd of April 2025, the magistrate dismissed Molife's bail application. The bail proceedings before Magistrate Martin in the Vereeniging Court and Magistrate's bail verdict are contained in the exhibit bundle that is accompanying my statement.
Thank you, Witness A. Commissioners, just for the record, the transcript of the first bail proceedings is in Exhibit CJC. It's 4.1 from page 1 to 235. And then the bail verdict that the witness referred to is CJC 4.2, which is from page 236 to 254. Witness A, your next topic deals with the Molefe bail appeal. Can you just tell us in terms of paragraph 106, we're starting at paragraph 106, Firstly, were you involved at all in the bail appeal, and what was your involvement?
Yes, maybe with the permission of the commissioner, could I just mention to the attitude of the arrested person now, the applicant, on the 105 in the paragraph.
Yes.
On the day when his bail was denied by the court, he seems to be very angry because I was part of the team that was transporting him, or that was booking him in to the facility where he was held. He told me personally that he is not happy with the system, because when he slept the previous night, he was assured that he's going to get bail. And then he went on to say he also knows that there were people who went and met with the magistrate that was going to conduct his bail judgment at 3 a.m. of the day, which is why the bail judgment was then tainted against him. And then I said, but now how do you know all that? Then he said, all this will be dealt with during his trial. But he was very aggrieved about that. And then he went on to make other claims to say he knows that we're being funded from outside the police by people who are funding this operation against him. But those were the claims that he will occasionally make to say, I know that you guys are being funded by people to work on me because of that they are my enemies in whatever business that they are doing. This cannot be the police operation. So on that day, he was actually a very angry person. And then I assured him to say, as far as I will understand things on the side that I was standing, is that we are working on a normal police operation. And then it kind of extended to say even his arrest, the murder, the investigation into the murder of Swart is a planned thing to take him down. Then I told him to say, on our side, if it was not for him, or if it was not for the Tao and the other two guys having gone to execute that murder, or having gone to shoot and kill that murder, we wouldn't have met. I wouldn't have known that he existed. So there is no way that I could be personal with him, or there is no way that the team could be personal with him. So the only thing that made us to know him or to be connected to him is that now there was a case that we went and took over and worked, and then that case led us to him. Then he said even that it was a plan by the certain generals that are working against him. Then I told him that what he needs to understand is that when we started on this investigation of arresting the Taus and them, there wasn't even a case that was existing on the system. The case was not even registered. It was a new case that just randomly happened, then we found ourselves to be dealing with. It's not like it was a case to say, please come work on this case, this will be your suspect, you will have to arrest him and work on him like this. So everything happened naturally and randomly. But he didn't understand all that, but that was his conspiracies. Thank you, Chess.
Thank you, Witness A. Can you then proceed with the bail appeal? I had asked you what was your involvement in the bail appeal process, if any?
Actually, there was nothing that I had in a bail appeal process as my involvement, because we had already done our investigation previously in his bail that was not granted. And then the case was then transferred to Pretoria, or I would say his bail was going to be held in Pretoria, which will then mean that it was going to be done by a different prosecutor other than the prosecutor that was doing it at the regional court, at the lower court in Vereeniging. It means now witness B and myself, we had a duty to go and meet with the prosecutor that was going to conduct bail on this accused person. Then the only role that I played was to go and have a meeting with him. I think it was on 2 occasions, just to make him familiar with what is happening in this case. What is Katiso charged for? Who is he charged with, even though they were not applying for bail, and the nature of the cases that are falling under the Vereeniging case, as I mentioned when I started yesterday, and to also give a little background to him that there is a case where Mulife is not arrested, but that we believe that it is actually the case that led to have Ahmad Swart killed, which is now the case of fraud and corruption at Transnet in Johannesburg. And then we also gave him a little background of that case, and also gave him an actual docket, as to say, maybe for him to understand how this matter of Ahmad Swart, he will have to read this docket against each other. But now he said he doesn't actually have time to read through these thick dockets, because the one that we were bringing then, it was also a thick docket on its own. And then this one of Mr. Ahmad Swart matter, it was also a very thick docket. Then he said he will concentrate on this, and then if he need any other information, then he would liaise more, especially with witness B, who had more information on the murder case docket.
Thank you, Witness A. Commissioners, the notice of appeal that's referenced in paragraph 106 is CJC 4.3 of the exhibit bundle, which can be found at page 255 to 263. Witness A, you're now on page 34 of your statement at 108, where you deal with the bail appeal hearing. Can you take us through that, please?
Yes, this day now was the day which was given to us by the prosecutor that was dealing with the appeal. Then he told us that the appeal will be held in Pretoria High Court. Then he gave us the courtroom number, and then he asked if we would like to attend the court. Then we did. But maybe I just should mention that prior to this bail, we had already received information from informers and sources to say Katiso Mlifi will get bail. They went as far as giving the figures as to how much he's going to pay for his way. But now that information will be dealt with more by witness B. What I just wanted to highlight here is that at the back of our mind, when we went to the courtroom, we already knew that this is what has been said to us. And then we didn't know if it was going to transpire the way they said it, or not. We also raised it with our commanders to say, this is the information that we received as a team, to say, this man is going to get bail. And then this is how much he paid for his bail. I'm not paying now bail money. I'm saying paying the process of him to be giving bail against all odds, which then was talking to corruption from the system. We didn't understand exactly if this system was going to be in the judiciary, like the justice system, or the NPA, because we're now dealing with the NPA. We just started trying to establish a relationship with the new NPA personnel, the prosecutor. We didn't understand him that much. Is it him who is going to receive this, or is it going to be the judge? We didn't even know the judge. But now we were told that this is what is going to happen, and then this is the figure that is going to be paid for him to get bail. Not the figure to say this is how much that you need to pay for you to get bail, but this is what you will have to pay for you to get to be admitted to bail, if I'm making it clear to the Commissioner.
I'm sorry. I know you are still going to come to it, but was the figure eventually, or at which bail was eventually fixed, the figure that you had been told by this person?
Yes, the figure that this is what I'm trying to elaborate on, Chair. The figure that I'm talking about here, it's not the figure that is going to be fixed to say he's going to be granted bail at an amount of maybe 1,000 rand. No, but it is the figure to say you pay me this much so that I can give you bail at a region of 100,000 rand, for an example. So this is the figure that was given to us to say he is going to pay 2.5 million for him to be granted bail.
Witness A, can I ask you about the bail appeal hearing that you deal with? So you've dealt with other issues, but can you deal with the bail appeal?
Yes, the bail appeal, as I say, we attended to it with witness B. As much as I would not be an expert in law, but with the experience as a detective, I have attended a lot of bail applications. And then you could hear halfway through the bail hearing to hear that is it going to be in favor of the accused person, or it is going to be in favor of the police. Then on this one, it was it was pre-concluded before it started that he's going to get bail on that particular day. And then this was now the conduct of the presiding officer that was conducting bail, or was presiding on the proceedings of the day.
Witness A.
Now,
please proceed.
Yes. Now on this, maybe it will be just my feeling or my understanding of the things as they were turning out, that, or they were playing themselves out, or maybe it was because of the information that we already had received on the days leading up to this bail appeal. But when we sat there, we also even called the office, our commanders, and said and asked to be excused because we couldn't bear listening to what was going on in the bail hearing. It was traumatizing. It was a bad experience. But now we were told to say, if you leave that room, who is going to give feedback to us to say this was the mood on the room? the commanders said, we know that we will get the bail judgment as in the form of a written bail judgment, but we wouldn't be able to know what was the mood and what was the attitude of the court officers, if I might call them that, during the proceedings, and then we were requested to sit through the bail hearing, which we did.
Witness A, what were your observations that made you upset?
My observation, and one of my few observations that I took note of, was that the judge was not really willing to listen to the submissions of the prosecutor, but he was interested to listen more to the submissions of the defense, in as far as even assisting the defense where they were making the submissions, to make an extension of the submissions.
What are you referring to, Witness A? We do have the transcript of the proceedings for the benefit of the commissioners. That is CJC 4.5, and it is from 290 to 353.
Yes, there is somewhere where the judge, without having maybe informed by the defense, to say the applicant has already handed over the passport or his travel document to the investigating officer, but he just took it upon himself to say Molefe had already done that, hasn't he?
Witness A, when you say he had handed his passport over to the investigating officer, what are you referring to? When did this occur?
I think the travel document, the passport, was handed to witness B when he was applying for his bail at the lower court in Vereeniging, if I am correct.
And what is it that you were saying about the passport?
The judge asked the applicant's lawyer to say, why did he give the travel document to the investigating officers?
But what do you make of that? Isn't that something that would form part of bail proceedings or a bail appeal, to be asked if the passport has been handed in?
Yes, but it was now, to me, I understood that. Maybe can I just please, with the permission of the commission, read paragraph 108 into the record?
Yes, you may.
Yes, it goes as follows. The judge asked Mlife's counsel why Mlife gave his passport to the investigating officer upon his arrest. In response, Mlife's counsel said that by giving the passport, Mlife was indicating that he cannot leave the country. The judge, in response, asked Mlife's counsel if she is saying by this that Mlife is playing open cards. Now, that was now the extension of the judge, as far as I could understand, to say your submission to court need to extend to say my client is playing open cards to the police. But this is not what the defense was saying. It was the assistance from the judge to say, do you mean or are you telling this court that your client was exhibiting that he's playing open cards to the investigating officer that I am not going to leave?
Okay, you may continue, witness A. Oh,
And
yes.
however, this was an exchange initiated by the judge, not the counsel, as I have just mentioned. What the judge did not take into account is that Molefe is known to travel with a false travel document. It should not matter that this was done 20 years ago, especially since he is now facing a very serious charge of murder. He actually, if I remember correctly, turned his attention to the prosecutor and said, the fact that this applicant used a fake or wrong travel document to travel to a foreign country, what value can I make of it in this application? Now, to me, that was I understood it not to be proper.
Why do you say that?
Towards,
Oh, sorry, continue, witness A.
then I'm reading now 108.2 to the record. Towards the end of the submissions, the judge asked
Sorry, witness A. Witness A,
before you do that, I think Miss Sigal-Ncube, for completeness, it might be that you have to refer the witness, or the witness should refer us to where this exchange happens in the transcript, because for someone who doesn't see that transcript, what is written in 108.1 can easily be understood as this is information the appeal judge had from an unknown source, and then he raises it. So I think we do need the context. Was this in the papers, in the bail application, this issue about the passport having been handed in, and maybe try and do that as much as possible with the rest of the complaints with reference to the transcript.
I will do that, Commissioner Baloyi. Insofar as, should I start with what was on 10?
Yes, I think so.
That exchange happens at page 329.
This is annexure CJC
4.5.
You say page?
329.
Yes.
I just want to confirm with the witness that he's referring to the incident about the 20-year lapse in Mr. Molefe having used false documents. Is that the one you're referring to, witness A?
Will you please repeat the question for me? I didn't get it correctly.
You were saying that the judge asked how much weight should he attach, or what value, you used the word value, he should attach to the fact that Mr. Molefe had been found with a false passport 20 years ago.
Yes, and then I'm asking now, what is the question?
No, I was asking if that is what you were referring to earlier, that exchange.
Oh, yes.
Just so that we can find it in the transcript.
Oh, yes, correct. Sorry that I was not understanding the question.
No, that's fine. Then that exchange is at page 329. And it starts with the court at line 18. Witness A, can you go to page 329 of the CJC4 bundle?
Yes, Commissioners, I'm on it.
Let me ask my question of the witness. Witness A, in that 108.1, where you say the judge asked Molefe's counsel why Molefe gave his passport to the investigating officer upon arrest. My question is, was there evidence in the record, in the appeal court, that Mr. Molefe gave his passport to the investigating officer? Was there such evidence?
I think as far as I would know how this case was going, I would say yes, we were in possession of the travel document. But as for that being evidence to say this is when it was given and things like that, I don't think we had it. I don't know if I follow correctly, Commissioner.
Yes. What I'm asking is, when the judge asks, as you say in that paragraph, when the judge asks Mr. Molefe's counsel why Molefe gave his passport to the investigating officer upon his arrest, what I'm asking is, was there, before the judge, was there facts or a statement in an affidavit that says, that records that Mr. Molefe gave his passport to the investigating officer upon arrest? Was that information before the judge?
I wouldn't know if the judge had that as information in his disposal.
All right.
Or maybe he just had, as the arguments were made between the prosecutor and the defense lawyer of Molefe. I really cannot pronounce much on that, Commissioners.
All right. Thank you.
Commissioner Baloyi, we'll check the first bail proceedings to see if it was, but Witness B would be in a better position because she deposed to the affidavits in there, but we'll check that and get back to you.
Thank you, Mrs. Bill.
Witness A, you then, I think you've dealt with 108.1 and you were then getting to 108.2. Do you want to read that as well, or do you want to explain what you meant by 108.2?
I would request maybe to read it out to the Commission. Then it goes as follows. It says, towards the end of the submission, the judge asked Molefe's counsel what she wanted the judge to do in light of her submissions. Molefe's counsel indicated that she would like the bail to be set at 50,000 rands, 200,000 rand. She then proposed that the judge may make an additional order, since the state already has Molefe's passport, that he may not go out, he may not go within 3 kilometers of an airport, or a point of entry will be an airport, or exit the country. She even goes as far as to say or to propose that Molefe may even be ordered to stay in Gauteng or at his house, or be put in the on house arrest. Then on 108.2.1, the judge said, but Molefe stays in Gauteng and has a project in the Free State and also a child in KZN. Then Molefe's counsel indicated to the judge that the child should not be an issue because the child can travel to Molefe. Then the judge also made a follow-up point to say says that Molefe has a girlfriend in KZN and they have been together for 20 years, to which Molefe's counsel responded that the girlfriend stays permanent in KZN with the child. The judge continues to say that he hears Molefe's counsel's point, but the point that he is making is that granting bail should not be a punishment.
Commissioners, that exchange appears from page 321 of CJC 4, from line 15, where the court says, yes, what do you want me to do? Sorry, 321. 320. My apologies.
Ms. Sikasmude, perhaps you also want us to note or to refer us to page 320 right at the bottom, where Ms. van der Heever, where she proposes the bail amount, which is what the witness has just spoken to.
Yes, correct, Commissioner Baloy. The exchange starts on page 320 from line 15, and then it continues over the next 3 pages. In fact, 5 pages, I think.
Just witness A, as I understand, the child being referred to here is a 17-year-old. It's not a small child. Is that correct?
That would be correct, Your Worship.
You may proceed, witness A.
And then
you were at 108.2.3, starting there.
yes, and then the judge then asked whether freedom of movement should be interfered with. And then I must admit I was quite taken aback by this statement. Molefe's counsel capitalized on this opportunity to submit that no conditions should be imposed to Molefe's movement. And on 108.3, the judge then asked about a condition of reporting at the police station. Molefe's counsel stated that it was an additional burden on the police station, but that is a condition that her client Molefe would be willing to adhere to.
For the benefit of the commissioners, that exchange is at page 323. From the line that starts, court, should freedom of movement be interfered with?
I guess for completeness, so the should freedom of movement be interfered with, you find at line 5.
Yes,
3
at
to
line 5.
3. And maybe for completeness, the witness should read Ms. van der Heever's response.
Witness A, did you hear that? Do you have page
Yes,
323?
Yes, I did. I did hear it, Commissioner, but I was just looking at the lawyer's response where I needed to read from.
It starts, Ms. van der Heever, so it's line 6.
But I mean, in which bundle?
Oh,
Is it
in
on the
a page-
bundle on my statement?
No, in the bail bundle, page 323.
323, yes. On page 323.
Yes, do you see where the court says, should freedom of movement be interfered with?
Yes, I see that, Commissioners.
Yes. Commissioner Balois asked for you for completeness to read Ms. van der Heever's response.
And then the defense for the applicant said, so, my lord, I would submit no. I think so let me start there. I would submit that there is no reason to interfere with his movement because it is shown during the 8 months between the commission of the crime and the actual arrest that even when he traveled, he returned to his house. So there should not be. But in the event, for instance, that your lordship does have potentially think I should consider imposing certain conditions, I submit that your lord can.
Thank you, Witness A. Do you want to now deal with 108.3? Oh,
yes. Then on 108.3, the judge.
Sorry.
oh, sorry. I think I'm sorry, Witness A. I think I'm misdirecting you.
And I think maybe just for the record, Witness A, the exchange you referred to in 108.2.1 to 0.3, we find that on page 322
It will be in page
of the transcript.
320.
Can you just go there and confirm for us on page 322? Maybe starting from line 10 to 25. You don't have to read it out, you can just confirm it.
Yes, I'm on the page.
Can you just confirm it for us that where in your statement from 108.2.1 to 0.3 you refer to what the judge said that is set out in 322 of the bail bundle?
Yes, Commissioner. I think now I'm getting lost between these two documents because I need to refer to this one and go to that one, and actually I'm not really used to it. I get lost in between. But I hear what the Commissioner is asking me to do. But I cannot really relate the lines from this document to the lines on this other document.
I think if I may try to be of assistance, Witness A, you in your statement in paragraph 108 and all of it, 108, 108.1, 0.2, 0.2.1, 0.2.2, 0.2.3, you're recording issues that happened or exchanges in court that happened that have caused you concern, right?
That is correct, Commissioner.
Yes. So I think what we are seeking to do for purposes of the record at least, it's to ensure that in the transcript, in the bail transcript itself, these concerns that you have recorded in your statements, we can relate them to what is in the transcript. So if you look at that page 322 in the transcript, do you have that in front of you?
I do, Commissioner.
Yes. So in fact, go back to 3.21, sorry, in that transcript.
I'm on it, Commissioner.
Okay. Now you will see there's a long paragraph right at the top, and then there's the next paragraph which starts with court in capital letters. You see that?
Yes, I do see that.
Okay. And then you go down, and then there's, in fact, the first is court, then there's Ms. van der Heefer, who was Mr. Molefe's representative, as we can see from this transcript. That's correct, right?
That is correct.
And then you have second court, and then you have second Ms. van der Heefer. You see that?
Yes, I do see that, just under 20.
Yes, and then, yes, just under 20. In fact, the second line after 20 is court, where the court says he has got a child in KZN. You see that?
Yes, I do see that, Commissioner.
And then Ms. van der Heefer says yes. And you see that?
Yes, I do see that.
And then the court says, so are you saying, and then there's a full stop. That's all it says in that line. You see that?
I do see that.
And then the last van der Heefer, Ms. van der Heefer says, no, the child, my lord, the child is not an issue. You see that?
That is correct. I do see that. It will be the last sentence of...
The very last sentence. So what we are seeking to relate is in that last line. When you go back to your statement, paragraph 108.2.1, you speak about the child there in your statement now.
That is correct, Commissioner.
Okay. And in that statement, and this is where you're saying the judge raised issues that the representative was not concerned about, right?
That is correct.
Okay. So in 108.2.1 of your statement, you say, the judge said that, but Molefe stays in Gauteng and has a project in the Free State and also a child in KZN. And then you say Molefe's counsel indicated to the judge that the child should not be an issue because the child can travel to Molefe. It's that last line that you're referring to in the transcript, right?
That is correct.
Okay. Now, and then the next, go to page 322.
On page 322.
The very top says court, and then this is the judge asking, must he get permission? You see where I'm reading?
I do see it will be the first sentence.
And then the next one is Ms. van der Heefer says, I respectfully submit the child should not be an issue. The child can travel up. The only, and then it ends there. You see that sentence?
Yes.
So it is that exchange that you are complaining about, that even though, at least that's how I understand your statement, even though Ms. van der Heefer said the issue of the child living in another province was not an issue for Ms. van der Heefer, the judge raised it as a concern. That's the kind of, I'm understanding you to be registering that as one of the issues of concern that you're raising.
That is correct, Commissioner.
Okay. And then perhaps in the same vein, in that very same page, if you go to, and maybe let's go to your statement, 108.2.2, you say the judge then says that Molefe has a girlfriend in KZN and they've been together for 20 years. You see that?
I do see that.
Okay.
Commissioner.
Now go to page 322 of the transcript.
I'm on it, Commissioner.
Okay. If you go from 1 to, so there's court, I just want you, don't count the line numbers. I just want you to look at where it says court and then Mrs. van der Heefer, right? We start with court right at the top, and then there's a second court as you go down. There's a third court.
Yes.
There's a fourth court just above the number 10.
Yes.
And then there's a third court, there's another court after Mrs. van der Heefer, just after 10. You see that?
Yes.
And then there's another court which starts, I am saying that I've read somewhere. You see that?
Yes, I do see that, Commissioner.
In the transcript. So it says, I'm saying I've read somewhere that the girlfriend stays at KZN. You see that?
I do see that, Commissioner.
Okay. So go back to your statement 108.2.2. You say the judge then says that Molefe has a girlfriend in KZN and they have been together for 20 years, right? You see that in your statement?
I do see it, Commissioner.
Okay. You confirm that that which is in your statement refers to what I've just read now in page 322 in the transcript.
That is correct.
Okay. It's that exchange that you are referencing.
That is the exchange that I am referring to, Commissioner.
Okay. Thank you. Thank you, Witness A. Ms. Eagles, you can take it from there.
Thank you, Commissioner Baloy. Do we then...
And thank you, Commissioner, for assistance in that regard.
Okay. Commissioner Baloy, do we then do from 108.2.3 or...
I think that's what Commissioner Khumalo was asking of you,
Okay.
so that the record reflects.
Okay, so perhaps you can then complete 108.2.2, the exchange in the transcript, not in your statement, which Commissioner Baloy had just referred to you, where the court says, I am saying that I have read somewhere that the girlfriend stays at KZN. Which part do you want him to read into the record?
Maybe just for completeness, he can start in line 19 on page 322 and end in line 5 on 323, because that would complete his paragraph 108.2.3 in the statement.
Thank you, Commissioner Khumalo. Did you hear that, Witness A?
Yes, I did hear that from Commissioner. So that will then mean that I'm studying from where the court says they have been staying together for 20 years.
Yes.
And then the legal representative says yes. So they have been together for 20 years, my lord. But she permanently stays in KZN with the child. Then the court says, yes, I hear the point. The point I am making is this. Granting bail should not be a punishment.
Continue.
And then the lawyer will say, no, my lord, and it should definitely not be. The case law is quite clear on that, and you still have a right to be presumed innocent until such time as you prove it guilty. Case law also says you cannot be incarcerated in anticipation.
Thank you, Witness A.
And then,
Thank you.
thank you.
So then if we then you go to your statement at page 35, paragraph 108.2.3.
Yes.
Are you in your statement now?
I'm on my statement now.
Okay. Perhaps you can then just read that again into the record, and then we'll do the exercise in the transcript.
The judge asked whether freedom of movement should be interfered with. I must admit I was quite taken aback by this statement. Molefe's counsel capitalized on this opportunity and submit that no condition should be imposed on Molefe's movement.
Okay. Now if you can go to the transcript at 323. Do you have it?
I do have it.
Where you see the first court. Can you read from there?
Yes. then now it is the court who is addressing the court or the proceedings. Should the freedom of movement be interfered with, then the lawyer said, so my lord, I would submit no. I think so let me start there. I would submit that there is no reason often to interfere with his movement because it is shown during the 8 months between the submission of the commission of the crime and the actual arrest that even when he traveled, he returned to his abode home. So there should not be. But in the event, for instance, that your lordship does have potentially think I should consider imposing certain conditions, I submit that your lordship can and have just given your lordship and as have just given you your lordship. And that is the point I was trying to make. The kind of conditions that your lordship should impose, however, I think based on the conduct before, there is no reason to impose any condition in this particular matter. May it please the court. And then the courts.
No, thank you, Witness A. We'll then move to the next one on your statement now. At page 35 of your statement still, paragraph 108.3. And could you just move closer to your speaker because the sound quality has gone down a bit?
Yes, Commissioners.
Much better, thank you. So can you read 108.3 on page 35 of your statement?
There's 108.3 will read as follows. The judge then asked about a condition of reporting at the police station. Mulifest counsel stated that it was an additional burden on the police station, but that it is a condition that her client, that will be now, Tadiso Mulife, will be willing to adhere to. The judge also asked that it was in fact another burden because you may find that the investigating officer, which will now be witness B, is not there at the police station, but at least it could keep the investigating officer happy.
Then if you can go to the transcript, still on page 323, line 20, you see there's court, there's a number 20 and court next to it.
Yes, Commissioner.
Can you read that into the record?
It starts where the court says, and the reporting at the police station, which is a question.
Correct.
And then the lawyer will say, my lord, I always think it is just an additional burden that is placed on the police station for somebody to hold the book there and do it. But again, it is a condition that can be placed by the court, and my client I have consulted is quite willing to adhere to such a condition. Then the court said, in fact, it is another burden because you find the investigating officer is not there. And then the lawyer responded by saying, indeed, my lord. But at least, that is the court now, but at least that could keep the investigating officer happy.
Just read it just read it as it appears, witness A, not as you have it in your statement. So the court says, but at least that would keep the investigating officer, full stop, and then read Ms. van der Neever.
Ms. van der Neever now says it could keep the investigating officer happy. That is indeed so, my lord. And then the court asked, okay, anything further for now, then the lawyer says, yes, I have got no further submissions for now. And then the court, thank you very much, Mr. Mashile.
Thank you, Witness A. That's enough. Thank you. We can go.
Sorry, before you do that,
Thank you, Commissioner.
Mr. Gels, perhaps for completeness again, but also context, you could get the witness to look at page 321 of the transcript from line 1, but in particular line 1, 2, 3, 4, sentence starting at line 4, but in context of this last discussion.
Thank you, Commissioner Baloy. Witness A, if you can go to, first let's do it in your statement, page 34 of your statement.
Page 34 of my statement, let me just page, yes, I'm on page 34, Commissioners.
The last paragraph there, 108.2, can you read that into the record first?
Yes, towards the end of the submissions, the judge asked Mulife's counsel what she wanted the judge to do in light of her submissions. Mulife's counsel indicated that bail should be set at 50,000 rand to 100,000 rand. She then proposed that the judge may make an additional order, since the state already has Mulife's passport, that he may not go within 3 kilometers of a point of entry or exit the country. She even goes as far as to propose that Mr. Mulife may even be ordered to stay in Gauteng or at his house or be put under house arrest. That is the submissions by his legal counsel.
Thank you, Witness A. Then if you can go to the transcript from page 320.
From page 320.
Yes. And if you're on 320, if you can go to the court after line 20, after the number 20, there's court, the word court. If you can read from
yes, I see it. Then it goes like this. In the light of your submissions, what do you want me to do? And then the legal counsel responds, my lord, I respectfully submit that your lordship can find that the appellant should be granted bail. I think it is placed on record that at that stage that he can pay a substantial amount of bail. The court can, of course, look at his assets and determine for itself. I think the offer at that stage, is made of 50,000 rand or 100,000 rand. And of course, your lordship is entitled. If your lordship is so inclined, they already have his passport to make an additional order. For instance, that he does not go within 3 kilometers of a point of entry or exit in the country. He stays in Gauteng or he stays at his house, your lordship. Can even go as far as to put him under house arrest.
Thank you, Witness A.
Thank you, Commissioners.
Now, if we can then go back to your statement at page 36 at 109.
Yes, I'm on page 36 at 109.
Can you read that into the record?
Then it reads as follows. In contrast, the exchange between the judge and Mr. Mashile was completely different. From the outset of this argument, Mr. Mashile made it clear that Molefe had to prove that there are exceptional circumstances that justify his arrest in the interest of justice. The judge simply did not deal with this requirement. He persistently asked Mr. Mashile about what the judge considered to be areas of Magistrate Morton's bail verdict where he had misdirected himself, such as the magistrate stating that Molefe is a man of straw.
Thank you, Witness A. Then if we can go to the transcript at page 325. In fact, if we could start at page 324.
324, on page 324, Commissioners.
Yes. Could you read from just above line 20, where it's got the number 20, where Mr. Mashile starts?
Yes, Mr. Mashile is addressing the court, and then it goes as follows. And we stand by saying, and just want to elaborate and in the main respond to what was argued by my learned colleague, because at the time of drafting the heads as respondents, we do not have the benefit of what is in the heads of argument of the appellants. We only received some day or so ago. But that being said, in deciding the matter, the court in our submission should be alive of the fact that in bail applications, and of course this nature, as it was common, or as it was common cause that falls within section 60 bracket 11 bracket A, the onus is on the appellant. Then the court responds on the balance of probabilities. And then Mr. Mashile also addresses the court on the balance of probabilities to prove that there are exceptional circumstances that justify his release in the interest of justice. Your Lordship will see and that we deal with all of those aspects in our heads of argument with regard to the personal circumstances of the accused, of the appellant. It may be so that they appear as they are on the affidavit. Then the court says, is he a man of straw, as the magistrate stated in his argument?
Thank you, Witness.
Mr. Mashile addresses the court.
Thank you, Witness A.
Extent.
No, thank you, Witness A. That was
Yes.
insofar as what you say in your statement is reflected in the transcript, or what you say is reflected in the transcript at 109. And that's
Yes,
what we
yes.
just...
Commissioners.
And then at 110 of your statement, page 36, can we go back there?
Yes, I'm on my statement 110 of page 36.
Yes.
And then it reads as follows. When Mr. Mashile submitted to the judge that Molefe's previous conduct of traveling with false document was relevant because it showed that he was capable of such conduct, especially now that he is facing a serious charge. The judge said that Molefe cannot create false documents alone and asked Mr. Mashile whether he was saying that the Department of Home Affairs is not competent.
Thank you, Witness A.
Thank you. Witness A, I want to take you back to paragraph 109 of your statement in line 4. So starting from line 2, you say from the outset of his argument, Mr. Mashile made it clear that Molefe had to prove that there are exceptional circumstances that justify his release in the interest of justice. And then the next sentence that follows is, the judge simply did not deal with this requirement. Are you saying there that the judge in his judgment did not deal with the requirement of exceptional circumstances? Or did not say what the exceptional circumstances were? What is the point you are making there?
I'm saying that the judge did not really exhibit the circumstances, the exceptional circumstances that need to be exhibited by the applicant to say he has given the exceptional circumstances to the satisfaction of the court, and these are the circumstances that the court is considering that will qualify him to be a candidate of bail in this regard.
Now, I need you to go to the judgment itself on page 363 of the
363
of the annexures bundle. Yes.
Yes.
Are you on page 363?
I'm getting to it, commissioners. Yes, I am on page 363, commissioners.
Yes, so in line 20, if you start from line 19, do you want to comment on that paragraph in its entirety? And then go to the next page, starting from line 8 to line 11. Just comment on those two paragraphs in their entirety, in light of the statement you make in paragraph 109.
Yes, this paragraph will start at, in my view, there are exceptional circumstances viewed in conjunction with his personal profile, on the basis of which the court should find that the applicant should be released on bail pending his trial in order to avoid excessive prejudice to the applicant. The learned magistrate, in my view, misdirected himself in determining whether exceptional circumstances exist or not, in that he disregarded that the applicant has assets and can therefore not afford to pay bail.
Yes, continue. Up to line 11.
Yes, Commissioner, I didn't get that.
Sorry, I'm saying you can continue reading until line 11 on that page.
Oh, yes. I am further of the view that to find that because the applicant has previous convictions of about 20 years ago, and that the applicant used a fraudulent passport, he should therefore be regarded as a flight risk. That, in my view, is a material misdirection. I find that there are exceptional circumstances justifying that the applicant should be released on bail, as some will be in the interest of justice for reasons that I have said above. Because of that, I make the following order.
Sorry, Witness A, I think you can pause there because the judge then deals with the orders that are made. But
Yes.
Going back to your statement, I just wanted to understand your criticism of the judge. Are you saying the judge did not mention exceptional circumstances, or is your point that the judge did not say what those exceptional circumstances are?
I am saying he didn't really exhibit what those exceptional circumstances are in his addressing of the court.
Yes, thank you.
Thank you.
Commissioners.
Thank you, Commissioner Kumalo. So, witness A, are you saying that the judge mentioned exceptional circumstances, but you don't know what those exceptional circumstances are when you read his judgment?
Yes, I'm saying, as far as I understood, he did mention that there are exceptional circumstances, but he didn't mention them expressly to say 1, 2, 3, 4, to whatever number. These are circumstances, the exceptional circumstances that are exhibited by the applicant that will.
Sorry, witness A, we're losing you again. Witness A?
By him to be the candidate.
Witness A, we're losing you again. Can you hear us?
Yes, yes. Yes, Commissioners, am I...
Please repeat everything you just said, witness A.
Yes, thank you, Commissioners. I was saying that the judge does mention that there are circumstantial exceptional circumstances that will now qualify the applicant to be released on bail, but he didn't mention them to the court for all parties to hear what they are.
But is it not so? Let us look, witness A. Let me just count the lines. 1, 2, 3, 4, 5. I think around line 15, the indented paragraph starting, I think. Do you see that?
Can you see the screen, witness A?
I do see the screen.
So there the judge says, I think the applicant has succeeded in demonstrating that factors listed in section 64A to E of the Criminal Procedure Act are not present, combined with the fact that he would suffer substantial prejudice should he be incarcerated pending his trial. In my view, there are exceptional circumstances viewed in conjunction with his personal profile on the basis of which the court should find that the applicant should be released on bail pending his trial in order to avoid excessive prejudice to the applicant. Am I mistaken if I say in context, this is a conclusion based on what the judge has said before?
I think if I understand this, as I will also like to declare to the commission that I'm not a legal expert, but when I'm reading that, layman as I am, the judge is making a ruling there. He doesn't expressly tell the court to say the applicant has exhibited these exceptional circumstances and here they are. But he just says he did exhibit them, but what are they? To this day, I do not know what they are or what they were at that time.
Thank you, Chair. Witness A, you then were dealing with at page 36 of your statement, paragraph 110, you had read into the record about the reference to Home Affairs not being competent. Do you recall that? At 110?
I do recall that, Chase.
What is the point that you had wanted?
Years.
What is the point that you had wanted to make?
I wanted to make a point that at that time I understood this to say the applicant is not going to be able to do, is not going to be able to have or to make means of having a false passport again on his own, unless if Mr. Mashile was telling the court that he does not trust the competency of other institutions of state, like in this instance, the Department of Home Affairs. And then I understood that to be something that I really could not understand properly, to say, as much as we understand Home Affairs, and maybe like trust and believe in them, but we're sitting with a person who has done this before, and then when he did that, Home Affairs was already there, and it was trusted that it is. Why would it be, in a sense of Mr. Mashile to say, I don't trust that department? I'm thinking maybe it will collude with the applicant to do this. I think that was a misdirection, or it was the judge was misdirected there. We were dealing with the capabilities of the applicant, not other institutions. And then he had exhibited before that he can't do that. He had done it, and the proof is before the court that here is a person who goes around crossing boundaries of countries, using false documents and using false identities, even though these departments were there, and then they were said to be competent as we believe they are.
Thank you, Witness A. Commissioner Baloy, do you want us to go to that reference in the... Okay.
I think for completeness we should.
It's at page, starts on page 329 of the bail bundle.
Yes, Commissioners.
Do you have it?
Yes, I'm on page 29.
329.
329.
329 of the bail bundle.
Yes.
Where the court says, you can start from Mr. Mashile next to line 10.
Yes. Mr. Mashile then said, no, my lord, but it is information that was at the disposal of the investigating team, and which information they took serious and acted upon. Furthermore, your lordship, on this aspect of the flight risk, my colleagues emphasizes that the applicant played open cards by making his passport available. Yes, we do agree that is the position, but this aspect, your lordship, must also be taken in conjunction with the past conduct.
Continue.
Then the court went on and said, of about 20 years ago, how much weight should I put to that? He had a false passport. He used a false name in the UK. How much weight should I put to that? Then Mr. Mashile says, your lordship, that is being confirmed by yourself. To say you are giving it to the court, yourself, your lordship. Then the court says, yes, it is not an issue. That is why I'm asking how much weight should I put to that. Then Mr. Mashile says, my submission, your lordship, is that it is weighty enough to say this appellant is a kind of a person who is able and can be able to have and obtain false documents and use alias names, travel out of the country without detection, and therefore the lapse of time of plus minus 20 years, Your Lordship, in our submission does not play any role. What matters is the conduct, the character, what he has done in the past. He is capable. Then the court said, yes.
Continue.
Then Mr. Mashila went on and said, yes. So on the affidavit that he had lost contact with those people, I will submit that does not avail him in this regard. In other words, he knows how to go about because then the court says he cannot do it alone. So are you saying that our Department of Home Affairs is not competent enough because he cannot do it alone? Then Mr. Mashile responds and say, indeed so, Your Lordship. Your Lordship, he cannot do that alone. But the fact of the matter is that it is possible and it was possible and he did it. Then the court says, and it happened. That is the question. Then Mr. Mashile says, he says, and it happened. Then the court said, yes. And your submission? Then Mr. Mashile, how sure are we that it cannot happen? Mostly especially now that he is facing some very serious charges which by their very nature, Your Lordship, in our event of conviction, carries the sentences of a very long term of imprisonment. Now that in itself, the situation or the position that he finds himself in this present moment might not have been a situation where he found himself in between when he last used the false passport and the alias link, and when he was arrested. In our submission, Your Lordship, the situation now changes, and my intrigue is to go back to his past conduct because of the factors that I have raised, the serious nature of the offense, the possible sentence in the event of conviction that can make it a petition for him.
An appetite
for him. My apology for that mispronunciation.
Thank you, Witness A. Then if we go back to your statement at page 36, at paragraph 111, can you read that?
Yes, I'm at page 36 of my statement, paragraph 111. The judge also pointed out that Molifes disclosed his past conduct and previous conviction. Mr. Mashile told the judge that this was only after the state had already disclosed it, and only then did Molifes disclose. The judge did not seem to appreciate the significance of this. The judge referred Mr. Mashile to a statement by Molifes' legal representative when the legal representative stated that Molife had disclosed the previous convictions to him during consultation. In other words, Molife had voluntarily disclosed the information which, in contrary to what actually happened.
Okay, thank you, Witness A. If you then can go to the transcript, page 331, you should still be on that page. And just the line where you see court after line 10, after the number 10.
Yes, then the court said that he did disclose his past conduct. You know, there should be a distinction in instances where a person does not disclose previous convictions and it is not disclosed by the state. But in this, do you agree that the applicant did disclose his previous convictions? Then Mr. Mashile says, yes, Your Lordship, ultimately he did disclose his previous conviction, although if one follows the record, it was only after. Fortunately for him, for the defense, they the benefit of seeing the affidavits of the investigating officer that will be now the witness B, even before. And there was, if you look at the record, there was a lot of postponement for the bail application, even to an extent that a legal practitioner had to depose to an affidavit, but the fact of the matter is that ultimately he did. And then the court, what is the legal practitioner saying in this affidavit about this aspect? He says that the applicant did disclose this to him as they were busy preparing, because I think in my memory, if my memory serves me well, another practitioner was instructed in the matter, but it is clear from that affidavit that he says that he did disclose this aspect. And Mr. Mashile goes on and says, yes, Your Lordship, emphasis, Your Lordship, is not placed on the fact that the accused or the applicant is a dishonored person. There is no submission in that regard, because ultimately that was, I am trying to answer the issue of the disclosure of the previous conviction. Then the court, so you submit that he is not a dishonored person. Is that your submission? Then Mr. Mashile said, look, Your Lordship, it will be difficult to make my submission in that regard. And then the court, what is your submission in this regard? Then Mr. Mashile says, does this relate only to the previous convictions or to the whole case as is against him? Then the court, on the previous convictions. Then Mr. Mashile says, on the previous convictions, Your Lordship, because we actually do not know what happened.
Thank
then
you.
The court says, okay, continue with your submissions.
Thank you, Witness A.
And then, thank you, Commissioners.
Witness A, may I just ask this? At page 331, where you started reading, I think just 3 lines, where it says Mashile at about line 15. Remember, you have that number 10 and then you have court. You started reading from there, right?
Yes.
Okay. And then after that court, there is Mr. Mashile. And he says, yes, Your Lordship, ultimately he did disclose his previous conviction, although if one follows the record, it was only after. Fortunately for him, for the defense, they had the benefits of seeing the affidavits of the investigating officer even before. What is it that you are seeking to communicate with this? I don't understand the significance when I read the record, the transcript, the significance of that statement where Mr. Mashile says they had the benefit of seeing the affidavits of the investigating officer even before. Why is that significant? Yes.
I'm thinking. Sorry, Commissioner.
Yes, no, you may go ahead.
Thank you. I think he was trying to convey to the court and painting the picture as how the situation played itself out in Mr. Mlife's bail in Vereeniging. He was just telling the court that should the legal team of Mr. Mlife not been able to see the affidavit by the IO beforehand, they were not going to be able to make the submission to the court in as far as disclosing that he had disclosed to the previous legal representative. And then maybe I also need to assist the commission that what happened at Vereeniging was that before the court could sit, the two parties will exchange the affidavits. The defense will give the affidavit to the state and the state will do the same. And then the affidavit had a tendency of going through the affidavit, and then before the court would sit, then they would say, no, we're not going on with the bail application today. There's issues that we need to consult our client on and sort out. That is when now they saw that actually the state was aware of the travel document and the previous convictions. Now they wanted to work the plan to say, how do we now cover this? Because in their initial bail statement to the court, there was no mentioning of the previous convictions because they thought we were not going to be able to find them until they saw it in our bail application. Now they said, hey, we are sitting with a problem. How do we devise the mechanism to say, we know about this, we did disclose to the previous legal defender, and then we thought he would have told the court, but it did not. Then can we please just disclose it and maybe tell the court that actually it is not the fault of the applicant, but it is the fault of the previous legal defender that didn't bring it to the attention of the court at that particular time. So that was just playing with the mercy of the court, if I may use that term.
Thank you, Witness A.
Thank you, Commissioner Baloyi. Witness A, if we can go back to your statement, then we're now on page 37 at paragraph 112.
Yes, Commissioners, I'm on 112 paragraph, page 37, paragraph 112.
Yes. Can you read that into the record?
Yes, thank you, Commissioners. It reads as follows. Mr. Mashile again stated that even if the magistrate disregarded himself in some respect, he did not do so insofar as he found that Molefe did not show that exceptional circumstances existed.
Thank you, Witness A. Can you then go to the transcript bundle, page 336?
Yes, Commissioners, I am bail bundles, page 336.
And then you see where it says line 10, Mr. Mashile.
I do see that.
Then it says court. Read the second, Mr. Mashile.
Oh, yes. Then Mr. Mashile will address the court and say, but what I am saying is that they may find, if this court were to find that on two, for an example, on two aspects, the magistrate was unjustified in making certain conclusions. Part of our submissions, Your Lordship, does not necessarily mean that the magistrate was wrong in the final conclusion that the appellant failed to discharge his honors of proving exceptional circumstances, which in the interest of justice requires his release. Our submissions, especially Your Lordship, when one takes into account the aspect that related to him being a flight risk, which in our submission that is the most without putting the other factors. Your Lordship, in a
hierarchical. You can continue.
Oh, yes, manner. But at the end of the day, one plays an important role in considering whether to grant bail or not. The court has to consider and look as to whether, looking at the facts, is the accused or the appellant or the applicant for bail is granted bail will be able to attend court until the finalization of his trial. And in this regard, the magistrate, in his judgment, found that that was not the case. And in our submissions, the magistrate could not or cannot be faulted in that respect. In the main, Your Lordship, we submit that despite the misgivings that the court might have insofar as certain conclusions that the magistrate might have come to without being supported by the evidence before him, the ultimate decision that he was not convinced that the appellant proved or discharged his honors of proving exceptional circumstances cannot in the circumstances be faulted, Your Lordship. That is our submission, unless the court would like to hear me on any other aspect. That will be our submission.
Thank you, Witness A. And then if we can go back to your statement at page 37, paragraph 113, if you can read that paragraph.
Page 37, paragraph 113 goes as thus. The exchange that stands out the most for me at the hearing was when the judge raised the issue of Tau's being granted bail. As previously stated, Tau was granted bail on medical grounds because he alleged that he was diabetic. His diabetic condition had deteriorated while in custody. The judge asked Mr. Mashile, what is it about Milife that he should not be entitled to bail if Tau, who was arrested immediately after the crime was committed, was granted bail? Mr. Mashile correctly said that he did not deal with that bail application, and the judge continued that the only reason Tau is back in custody is because he breached the bail conditions.
Can you read 114 as well?
114 says the judge did not ask what exceptional circumstances were taken into account in Tau's bail application, which to me would have been the most important aspect of this exchange.
Now, if Witness A, if we can then go to the transcript, and you were still on page 337, and you see line 20.
That's correct.
Just above it, you see court. If you can read from there.
Then it is court now saying, I want to hear you on accused one.
Can I just ask you who is accused one?
Accused one will then be Michael Puleta, who is accused number one.
Okay, continue.
For anything case.
You can continue.
Can I continue?
Yes.
Commissioner? Yes. Then the court is saying, do you agree that he was granted bail in this matter? Then Mr. Mashile says yes. The fact and the information that I have brought to you, Your Lordship, is that yes, indeed, he was granted bail. And then the court says, and was he also arrested soon after the deceased was killed? And then Mr. Mashile says, the very same day, Your Lordship, to be honest with the court, within a few hours. And then the court says, I thought that you were always honest with me. And then Mr. Mashile addresses the court and says, I have always, as officers of the court, within hours, within a few hours, the matter occurred around 7 o'clock in the morning in Vereeniging. The court then says, arrested on the same day, granted bail. Now, what is it with the applicant who should not be entitled to bail if accused one who was arrested immediately thereafter was granted bail? Then Mashile addresses the court by saying, Your Lordship, the disclaimer here is that I did not deal with the bail application for accused. Then the court says, it is a fact that he was granted bail. Then Mr. Mashile says, yes. Then the court says, he is inside because he breached the conditions of bail. That is now a question. Then Mr. Mashile says, yes, he breached the conditions of bail, and then he was cancelled and he was placed in custody. But our submission is in this, insofar as the appellant before this court, Your Lordship, is that there is a likelihood that if he is granted bail, given his past conduct, given the seriousness of the offense, given the possible sentences that he faces, that he will not stand his trial. And that is why the submission that the magistrate cannot be faltered in, our submission in that regard.
Thank you, Witness A. Witness A, can we then go back to your statement? Page 37.
Yes, Commissioners.
We are looking at 115. If you can read 115 and 16 into the record.
The 116 says, I am not a legal trained person, but
Sorry,
I have
Witness
been
A. I asked from 115, 115 and 116. Thank you.
My apology, Commissioners. 115 paragraph reads as follows. After Mulife's counsel made reply submissions, the judge took an adjournment of approximately 1 hour or slightly longer and returned with his judgment. The transcript of the judgment is also contained in the exhibit bundle. And then 116 will read as follows. I am not a legal trained person, but I have been present at countless bail applications, and I know that for Schedule 6 offenses, the accused must show exceptional circumstances. During delivery of this judgment, the judge kept mentioning the phrase exceptional circumstances, but not once did he mention what those exceptional circumstances are. Yet the appeal was upheld and Mulife was released on bail. The judge findings that exceptional circumstances existed had far-reaching consequences, which I deal with briefly later. I still do not know what exceptional circumstances the judge found existed that justified Mulife's release. And then paragraph 17 will read as follows. In settling the bail conditions, the judge imposed conditions that Mulife should be in the province of Gauteng and can only leave Gauteng after informing the investigating officer, which in this case will be witness B, in writing where he will be going, and the investigating officer should not object to him leaving Gauteng unless there is a valid reason. And then witness B will elaborate on this condition, because based on the condition, Mr. Mulife's attorney requested Mulife's passport from witness B. That is now after he has been released. The attorney indicated that there was no express order from the judge that witness B could keep Mulife's passport. The
Thank you.
judge also.
May I, perhaps for completeness, now that you are discussing the order or the conditions, if you would, Ms. Sikas Ngube, have the witness look at the transcript, witness A, at page 343, and then starting at line 5. And if you go if you go one page back, 342, at the bottom, you will see it says Mr. Mashile, and then it continues to the next page. Ms. Sigasnobe, perhaps you want to direct the witness to line 5 for the record?
Thank you, Commissioner Baloyi. Witness A, did you hear what the Commissioner said? Are you at the bundle? It's on the screen as well.
I'm on the bundle at 343, Commissioners.
Yes, line 5. That
It
is
will be line 5 of 343.
Yes, and that's a continuation of what Mr. Mashile starts in the previous page, 342. And from line 5, it is the conditions that he is asking the court to impose. Would you read that into the record?
Yes, it goes like this. With regard to the conditions, the suggestion is as follows. For the appellant to remain at home, well at the residence where he is currently staying or where he was arrested, and not to leave the province of Gauteng without informing the investigating officer, reporting to the nearest police station, and I am informed in this regard to the Sentin police station 3 times a week, Mondays, Wednesdays, Fridays between 8 a.m. and 8 p.m. and the normal bail conditions not to communicate or contact any of the witnesses contained in the witness list of the indictment which they already have.
Yes, thank you.
Then the court.
No, thank you, Witness A.
Thank you, Commissioners.
And then if you can go to page 118 page 38, paragraph 118 of your statement.
Yes, Commissioners. I'm on page 38, paragraph 118, where it reads, the judge also signed an order that had an obvious typo. This order is also in the bail exhibit bundle. In paragraph 2.3 of the order, the judge ordered that Mulife should interfere or communicate with the state witnesses. After the prosecutor complained about this, it was later rectified to reflect what the judge had said in his judgment. The amended order is also contained in the bail exhibit bundle, where the bail condition in paragraph 2.3 was rectified.
Okay, thank you, Witness A. If we can just deal with those documents. The bail appeal judgment is CJC 4.6. It appears at page 354 to 365. And to place on record what the judges, in his judgment, what the order had said, Witness A, if I could ask you to read on page 364. Just let me know when you're there. Yes, line 20.
Okay. Ms. Siggles, perhaps he should just read the whole order for completeness. It starts at line 12.
Okay, you can read the whole order. Witness A, we can't hear you.
Now start.
Witness A, we can't hear you. Just bear with us. Witness A, can you hear us?
Yes, I can hear you, Commissioners.
Okay. Continue. So you will read page 364 from line 12. That starts with based.
364.
Yes. You see line 10 and then it's got, so just read 2 lines down. If you look at the screen, it's highlighted on the screen for you.
Yes, I'm just trying to locate the page. 364. I'm seeing 364. I'm on the page.
Yes.
Yes, and then
line 12, so 10 and then just count 2. That starts with based.
yes, I'm on that, Commissioner.
Can you
Sorry
read
for the
that?
delay. Yes, it says, based on that, I make the following order. The learned magistrate ordered to dismiss the applicant's application for bail is set aside and is substituted with the order set out hereunder. And then 2, the applicant, Mr. Katiso Mulife, is granted bail in the amount of 100,000 with the following conditions. Then condition 1, he should report at the nearest police station twice per week on Monday and Thursday. And Thursday. 2, he should be in the province of Gauteng and can only leave Gauteng province after informing the investigating officer and writing where he would be going to. The investigating officer should not object to him leaving the province of Gauteng unless there is a valid reason for her to object. The applicant should not interfere or communicate with the state witnesses mentioned in the indictment. The applicant should attend court as ordered at his last appearance and on the dates that the trial would be postponed to. Should the applicant fail to comply with any of the conditions above, a warrant for his arrest may be issued and his bail may be withdrawn by competent court.
Thank you, Witness A. And then if we can deal with a typo in the initial bail appeal order, that is CJC 4.7. It appears at 366 to 369.
Yes, on that one, Commissioners, should I read the whole document?
Yes. No, just read the paragraph that deals with 2.3. If you can read 2.3 into the record.
Yes. 2.3 says the applicant should interfere or communicate with the state witnesses mentioned in the indictment.
That is the typo that you were referring to in your statement.
Yes, that is the typo that I was referring to in my statement.
But the judgment by the judge on the day said should not interfere, correct?
That is correct. That is correct, Commissioners.
And as you say, it was then corrected. If we go to CJC...
Just before you go there, I think to be fair, Witness A, there was a draft order that appears to have been prepared by counsel for the appellant, and it's on page 368. So it looks like the error arose because in that draft order, paragraph 2.3 on page 369 says the applicant should interfere or communicate with the witnesses. And that's the draft order that was made, an order of court.
Do you see that, witness A?
On page 369, if I heard the commissioner correctly.
Yes.
Yes.
So the error appears in 2.3 on page 369.
Yes, I do see it where it says the applicant should interfere or communicate with the state witnesses mentioned in the indictment. Yes.
Thank you, Commissioner Kumalo. And then if we can go to the amended bail appeal order, which is CJC 4.8, which is at page 370 of the bail exhibit.
Yes, I'm on page 370, Commissioners.
And then if you could just read 2.3.
Then 2.3 reads as follows. The applicant should not interfere or communicate with the state witnesses mentioned in the indictment.
Thank you.
Thank
Now,
you, Commissioners.
Thank you, Witness A. Witness A, you testified earlier about the, in paragraph 116 of your statement about the fact that the far-reaching consequences of the judge having found that exceptional circumstances existed in this bail appeal. Can you elaborate on what you're referring to? If you go to page 38 of your statement, and it's at paragraph 119 when you deal with the second arrest, Molefe's second arrest, bail application and appeal.
Yes. So does it mean that I go and read the 119 into the record?
You can if you want to, or you can address us, but whichever you prefer.
Oh, yes. Now it says on paragraph 119 on page 38, on the 21st of July, Molefe was arrested for the November 22 murder of DJ Opa John Sefuka, known as DJ Somebody, with Sandy Lemiers and Walter Mukwena. On the 6th of August 2025, Molefe applied for bail, and the application was heard before Magistrate Boshoff at the Alexandra Regional Court. The proceedings were televised. The transcript of the bail proceedings is contained in a bail exhibit bundle. During the argument, Molefe's counsel made the argument that on the 27th of June 2025, the acting judge president of the Gauteng High Court granted Molefe bail, and in so doing found that exceptional circumstances existed that justified his release in the interest of justice. Molefe's counsel argued that it had only been 3 weeks between Molefe's release on bail and his rearrest, and since there were no changes in circumstances during that period, the same exceptional circumstances that acting judge president in the bail appeal found existed then still exist when Molefe was arrested on the 21st of July 2025. On that basis, he submitted that Molefe had met the requirement of exceptional circumstances. This argument was relied on by Molefe's counsel repeatedly throughout. However, Magistrate Boshoff was not convinced, and he refused Molefe's bail application. However, on the 10th of October 2025, Molefe was successful in yet another bail appeal in the High Court, and he is current out on bail as we are speaking today.
Thank you, Witness A. Commissioners, that transcript of the bail proceedings appears at CJC 4.9 at page 372 to 455. Th- 372 to 455. Thank you. Commissioners, I realize that it's 4 o'clock, but there's just the conclusion for the witness to deal with, and I'm not sure if we...
Let's finish the witness, please.
I'm indebted to you, Commissioners. Witness A, can we then go to page 40 of your statement? Are you there?
I am the Commissioners.
Now, this deals with the media briefing of the 6th of July 2025 by General Mkhwanazi. You express your personal views of how that media briefing has impacted your life as a police officer. If you could just tell us more about that. If you prefer to read, you may do so. If not, you can express yourself as well.
Yes, Commissioners, and thank you for the opportunity once again. This will be now page 40 and paragraph 124, and then it will deal with the what occurred or what happened on the 6th of July 2025. And then this is where General Mkhwanazi made a brief or a public announcement about the issues that the police or the state was facing. And then maybe I can just read it into the record. Paragraph 124 says, I have been asked more times than I care to remember how I feel about General Mkhwanazi's media briefing of the 6th of July 2025. In my opinion, the media briefing was the best thing that could have happened to SAFT because it unrooted a lot of things that were not spoken about and brought out things that were hidden. The public has made aware of the challenges that we as investigators, ordinary, honest officers face when all that we are trying to do is our job. As an ordinary policeman, not a general or a commander, you feel that you do not have the authority or capacity or courage to speak out against these things or for fear of retaliation. It has also made our families to appreciate what our jobs entail and the challenges that we face. I am grateful to General Mkhwanazi for that media briefing because I have no doubt that had it not been for that briefing, the internal pressure of witness B and me to compromise the investigation would have gotten worse, and the investigation, as the investigation progressed, and the trial date got closer.
Thank you.
And the conclusion.
Go ahead, Witness A.
be.
Sorry, Witness A, we're losing you again. Witness A? Can you try again?
Continue with this investigation.
Witness A?
Yes, Commissioners.
Okay, can you hear us now?
I can hear you now.
We lost you after you said conclusion.
Yes, saying in conclusion, I am here today with my life change in ways that I could never have predicted simply for doing my job, a job that I had been wanted to leave more than once, multiple times in fact. I was wanted not to continue with it, and I am sure if I had gone to my commander and said the stakes are high, I would have been released from the investigation. But what do we say to the families who have lost their loved ones?
Witness
And
A?
they were dependent to the police like myself to get to the closure. Because it will then mean that they will have no one to turn to if it is us that are running away from the pressure that we are facing.
Witness A?
Yes, Commissioners.
Can you hear us?
I can hear you, Commissioners.
Okay, can you just continue from I was warned not to continue on 127?
I was saying I was warned not to continue with this investigation, and I am sure if I had gone to my commander and said that the stakes are too high, I would have been released from this investigation. But what do we say to the families who have lost their loved ones and depended on us to bring the murderers to book? Who will investigate these matters if we all choose to leave when the stakes got too high? I have been told that this investigation is dangerous and I am going to die. This is true. But if I had to do it all over again, I would. If I had received that call on the 17th April 2024, telling me to go to an active crime scene in Bramley, but if I do my life,
Witness A?
at risk, I will be in a safe house. I will do it again if I knew that it would make a difference in other people's lives. Even if the safe house options was not in place, I would still do it all over again. I have met the families of the victims, and and when I speak to them, they are grateful for the work that we are doing as a team, even those families where arrests have not yet been made. They appreciate that someone is working on the case to bring justice for their loved ones. The satisfaction of knowing that I am making a difference.
Witness A, are you okay? The witness is asking for a minute, Chair.
Let's adjourn. You'll let us know.
My apologies, Commissioners. Witness A, are you there? Witness A, you're muted if you're there.
Yes, Commissioners, I am here. And, sorry for disturbance in that part.
No need to apologize, Witness A.
Do you want
yes,
to
I was
proceed?
yes, Commissioners, I was at the part of saying what the address by General Mkhwanazi meant to me. And then I was saying it meant a lot because it was putting the problems that we are facing as a country or as the police in particular in a public domain. But more so, I think it meant a lot to the people and the communities and then the families of the people that have passed on in the hands of the criminals, killed by means of guns or violence that we are seeing in the country. I have met, I'm saying this, me and the team, countless of people who say, who tell us how grateful they are about the work that the police is doing. Not only this team, there is countless of other police members that are actually doing great job outside there, but they are not seen because they are not fortunate to be like us today, to be in the media, to have their cases spoken about in the media. But we know because we meet with them, we see with them at courts, we know what they are doing. They're doing far greater than we are doing. And then they also are members that always give us encouraging words to say, colleagues, we see what you're doing. You are giving us courage to put more efforts to what we are saying. What actually made me to be a little emotional was that there was a case that I didn't really talk about because I don't really want to touch on it much. There is a member of ours that we worked very closely with when I joined organized crime Gauteng, that was brutally killed for doing his job. And then I think, even though I didn't communicate with his family, I will just have to mention his name. His name was Sergeant Ndlovu, and then he was killed for investigating one of the cases that were referred to be of serious nature in Soweto. And then he was gunned down for doing that investigation, and then we hoped maybe that we will see the people that killed him being brought to book, but to this day we haven't heard anything about that case. And then when this thing happened to us last year, I was thinking about the situation that happened to him, to say we are going to be in the situation that he found himself in. So that's all that I really wanted to say in my conclusion, Commissioners.
Thank you, Witness A. And then if you could just for the record read 129 and 130.
129 is saying that I will do this again even in the next life. That is now means if I'm giving the situation like this, but knowing that it will make change or it will bring answers to the families of the lost people, I will do it again. And then finally, paragraph 130 says, may I say in conclusion that if change does not happen, and if it doesn't happen soon, we are doomed as a nation. I hope that my evidence before this commission, in the face of real and present danger to my life, will contribute to a change police service, or at the very least the beginning of a positive change to the police service and the country as a whole. Thank you, Commissioners.
Thank you, Witness A.
Before you do. In Witness A, in that paragraph 128, you have a last sentence that I think you should read into the record to the public.
The last sentence read as thus: the satisfaction of knowing that I'm. Oh, yes, Commissioners.
So I was saying that last sentence in your paragraph 128, perhaps you should read it for the public to finally hear your position on your work.
That will be the last sentence. It says the satisfaction of knowing that I am making a difference, no matter how small it is unexplainable.
Thank you.
Thank you, Commissioners. Thank you, Witness A.
Witness A, in paragraph 108 of your statement at page 34, do you want to please go there?
Yes, Commissioners.
Are you there?
Paragraph 108.
108, yes. Page 34 of your statement.
I am there, Commissioners.
Yes, the very first sentence. I'm going to say what I'm going to say in relation to the bail appeal, Mr. Molife's bail appeal, the first bail appeal. You mentioned the name of the judge there in the very first sentence of paragraph 108. But what I also want to add is that the name of the judge is a matter of public record. It appears at the very first page of the judgment, and it also appears on the cover page of the appeal proceedings before the judge. Is there a reason perhaps why you have not mentioned the name of the judge? I'm asking because we, and I in particular, have asked you, where you talk about a person or someone and you do not mention the name, we have asked you, or as I say, I in particular, have asked you, who is the person? Or are you willing to tell us who the person is? Maybe paraphrasing, of course. And then you would either give us the name of the person or say that you are not willing to give us the name of the person for reasons that you would then give. So in this instance, have you deliberately left out the name of the judge?
Chair, I don't know if I'm following correctly. Will that be on 108?
Yes.
Paragraph?
In your statement, the name is there,
Yes.
108, the very first sentence. But in your
Yes.
in your testimony here today, and I hope I'm not making a mistake, in your testimony here today, you did not mention the name. So it's in that context that I'm asking the question that I've just asked.
Oh, now I understand. I understand the chair. I think it was not a conscious decision that I took that I will not mention the name, because the name of the judge is of public knowledge. Maybe I just didn't realize that I'm not mentioning the name, and my apology for that, Chair.
Then for the record, please give us the name.
The name of the judge will be Acting Judge President Lidwaba.
Thank you, Witness A.
Thank you, Commissioners.
Thank you, Chair.
That's it for this witness.
We'll be ready at 9:30 tomorrow, won't we be?
Yes, Chair, we will be.
Let's adjourn and resume at 9:30 tomorrow.